Hello, so this is the lockdown law lesson on diminished responsibility. So I have done a shorter AO1 video and also an evaluation AO3 video. So that will kind of summarize what you need to know. So this is in a bit more detail in place of our regular law lessons. Okay, so diminished responsibility, first of all, it is a defence to murder. Now, it is not available to any other crime. So it's what we call a special defence. So it's only available to murder. Now, if you are successful with the defence, it will reduce murder to manslaughter, and it's called voluntary manslaughter. So because it goes from murder to manslaughter, we call this a partial defence. So it's a special defence and it's a partial defence. Now, the good thing about reducing murder to manslaughter is the sentencing. So the sentence for voluntary manslaughter is discretionary life. This means the judge does not have to give a life sentence. Remember, with murder, it's a mandatory life sentence, but for manslaughter, it can be life. So if the person's dangerous, then yes, give them a life sentence, but it doesn't have to be. So you could actually avoid a prison sentence. You would still have a manslaughter conviction, so you haven't got away with it, as people might say, not lawyers, not you guys. So yeah, you might not go to prison, which is good. There's flexibility. So what happens is the defendant is charged with murder. So somebody's died and they are claiming the defence of diminished responsibility. Now, what is very unusual with diminished responsibility is the burden of proof is upon the defendant. Other than insanity, in the rest of criminal law, the defendant doesn't have to prove anything because you are innocent until proven guilty. Why are you proving something? It's for the prosecution to prove something, or if it's a defence, they have to disprove it. But diminished responsibility says the defendant has to prove the defence on the balance of probabilities, and they have to give medical evidence to the court, which can be quite complex for the jury. Just reminding ourselves of the definition of murder. So the defendant unlawfully kills a reasonable creature in being under the Queen's peace with malice aforethought. Okay, the law on diminished responsibility used to be contained in Section 2 of the Homicide Act 1957, but this was recently updated by Section 52 of the Coroners and Justice Act 2009. Now, there are 3 elements to it, and I really like that. So I like structure because then I can go away and think, right, I've got 1, 2, 3 things to learn. Okay, and some of them have a bit more detail than others, but we'll go through that, so it's fine. So diminished responsibility, number 1, the defendant suffers an abnormality of mental functioning from a recognised medical condition. We'll come back to these. Number 2, this abnormality substantially impairs the defendant's ability to understand the nature of his conduct or to form a rational judgment or to exercise self-control. And then element 3, this provides an explanation for the defendant's acts or omissions. Now we're just going to go through each element with some cases, just as we would in a lesson, so it's a nice, clear, logical structure. I hope you think it is. Okay, element 1, there has to be an abnormality of mental functioning from a recognised medical condition. So they use an old definition of abnormality of the mind, and the case of Byrne, B-R-Y-N-E, says it's a state of mind a reasonable man would find abnormal. Now, Byrne, good case, Byrne was a sexual psychopath. I didn't even know that was a thing before studying law. So Byrne is a sexual psychopath who can't control his desires, and he strangled and mutilated a woman, and it was diminished responsibility, and they said that being a sexual psychopath is a state of mind that a reasonable man would find abnormal, which I think we could all agree with. This abnormality, whatever it is, abnormality of mental functioning has to come from a recognised medical condition, so you need to give the jury evidence of that. It can be mental and it can be physical. Examples: depression, paranoia, if you had like voices in your head, if you had some kind of delusion disorder, battered woman syndrome. The case for battered woman syndrome is, and do Google this, have a look. It's called Ahluwalia. So Mrs. Ahluwalia was married to her husband for over 10 years, and he emotionally and physically abused her for a long time and raped her. And she got to the point where she just could not cope with this anymore, understandably, and she set fire to him one night when he was asleep, and he eventually died. So she tried to argue self-defense, which is problematic because she waited until he was asleep. She also tried to argue the old defense of provocation, which is about snapping and killing someone. Again, her issue here was she waited until he was asleep. So it looked like a desire for revenge. So the jury convicted her of murder. And then when she was in prison, they decided that there was a condition called battered woman syndrome, and she was suffering from it. So it meant that mentally she wasn't thinking properly, and it's, I guess, a kind of depressive disorder caused by years of abuse. So they reduced her murder sentence to manslaughter on the basis of diminished responsibility. So battered woman syndrome is now a recognised condition. So that's really all you need to know for element 1. Now, element 2, the abnormality of mental functioning has to substantially, that's a crucial word, substantially impair the defendant's ability to understand the nature of their conduct, form a rational judgment, or exercise self-control. So what is substantially impair? Okay, the case of Byrne, our sexual psychopath friend, said it's up to the jury to decide whether the abnormality of mental functioning impairs his mental responsibility. So, I always think that's a cop-out. Leave it to the jury to decide. But I suppose there's flexibility, so that's good. However, Lloyd, the case of Lloyd, was a bit better in defining what is meant by substantial. So substantial does not mean total, nor does it mean trivial or minimal. So it's somewhere kind of in between. So in other words, substantial means more than minimal, but it doesn't have to be total impairment. Possibly also quite vague. You've got a case called Golds that backs this up. So Mr. Golds killed his partner whilst in a possible psychotic state. The trial judge told the jury that he would not be defining the word substantial as it was an everyday word, and they convicted him of murder. So the Supreme Court upheld this decision. So that meant the defendant was still guilty of murder. And they said, you don't need to define the word substantial because juries will understand it. And if for some reason they ask what it means, then you can give the definition that we've just talked about. So you can say substantial means more than trivial. Okay. So that then leaves us with the 3 things. What does it have to substantially do? Well, it has to substantially impair your ability to understand your conduct. So you don't know what you're doing. There are voices in your head. You think people are aliens and you're sent by God to kill them. So ability to understand your conduct, ability to form a rational judgment. So Byrne, our sexual psychopath, couldn't understand that that's not okay to do that. And equally, he couldn't exercise his self-control. So it's ability to understand conduct, ability to form rational judgment, ability to exercise self-control. That then leaves us with element 3. So your element 3, the abnormality of mental functioning, has to provide an explanation for the defendant's conduct. So basically, the defendant has to prove that the abnormality of mental functioning has caused him or her to act as they have done, so i.e. the killing, because we're looking at a murder here. So the abnormality doesn't have to be the sole reason for the killing, but it must be a significant factor. So just because you suffer from depression doesn't mean you're automatically going to get diminished responsibility if you killed somebody. There has to be a link. What this is saying is there has to be a link between your depression and the killing. So that's quite a straightforward bit to look at. The issue of intoxication, the textbook talks about this in a lot of detail. for my benefit and hopefully for yours now, I try and simplify this. So there's 3 issues to consider, is the way I think of it. If the defendant is intoxicated, so they're purely intoxicated, drink or drugs, can diminished responsibility be used? No, go with intoxication, which may or may not be successful. Now, it gets a bit more complicated. What if the defendant has an abnormality of mental functioning? So let's say they're paranoid and then they get intoxicated. So they're paranoid and they go and smoke a load of weed. So that's probably going to increase their paranoia. Let's say it does, and they kill someone. Can they have a defense of diminished responsibility? I think there might be moral issues with this, because if you know you've got a condition and you do something that makes it worse, should you be afforded a defense? Maybe you shouldn't. So the case of Deichmann, the defendant suffered from a depressed grief reaction and drank a lot of alcohol before killing someone. Now, so what you've got an abnormality of mental functioning, the depressed grief disorder, and then you've got a whole load of alcohol added into the picture. They basically said, the court said, yes, you can have a defense of diminished responsibility if your intoxication makes the condition worse. So the abnormality doesn't have to be the sole cause of the killing. You've then got the issue of what if people have drunk and taken drugs for a long period of time? It's going to messes with your brain. Maybe they're addicted to alcohol. Case of Wood was an alcoholic who killed his friend. They were arguing about whether alcohol dependency syndrome is a recognised abnormality of mental functioning. And the courts decided that yes, it is. So if you have a condition like alcohol dependency syndrome, and you are addicted to alcohol and it has damaged your brain in some way, then you can use the defence of diminished responsibility. So that is the content kind of in conjunction with your booklet that I have produced. I would watch this, fill in your booklet, use the textbook. Then I would have a look at the AO1 video that I've produced. So these are the short bullet point 10 things you need to know about diminished responsibility, absolutely crucial for revision. So remember AO1, legal knowledge. And then AO3, have a look at that video, because you would need AO3 if there was an essay. Okay, so lots to be getting on with, folks, and I will see you shortly.